So a challenge for both law and economics when it comes to competition law is to determine what is within the firm and what is outside. And for law, that means drawing on other areas such as company law and commercial law. And for industrial economics, it means that we need to remind ourselves about the theory of the firm. Now, this session looks at one aspect of this neglected area, namely the extent to which an online platform or online platforms are agents of their suppliers. We have two speakers, Pinar Ackman, who's a lawyer, and Kai-Uwe Kuhn, who is an economist. So we will have an interesting debate, I'm sure. And without further ado, I want to hand over to our first speaker, which is Pinar Ackman. So Pinar, if you could turn on your camera and microphone. Hi, Pinar. Pinar is a professor of law and the director of Center for Business Law and Practice at the University of Leeds. She's also director of the Jean Monnet Center of Excellence in Digital Governance, funded by the EU Commission. And there's a whole bunch of other things to say, but in interest of time, I'll let you read that in the program. Pinar, over to you.
Thank you, Morten. Hi, everyone. Can I have the slides, please? Thank you, Tom. Thank you, Morten, and many thanks to the CCP for the invitation to speak at the conference. So I recently published a paper in Fordham International Law Journal that looks at the question of whether platforms, online platforms, are agents and what the implications of this might be if they are agents for competition law. The paper is quite lengthy. To be precise, it's over 100 pages. And so I'm going to try and summarize the main arguments in the paper, as I only have 20 minutes. And hopefully anyone who would like to have a more detailed analysis of anything I say might like to read the paper, which is available freely online. So the paper is motivated by two questions, essentially. The first one is, what are online platforms from a legal point of view? And that question arises because we have many definitions of online platforms, but if we look at any of those definitions, we see that these are generally factual definitions of what an online platform does, and they don't necessarily tell us what an online platform is from a legal point of view. And of course, for the legal assessment of the practices of platforms, it does matter how we legally characterize an online platform. And one particular question in this regard is whether online platforms are agents, because in the context of competition law, if online platforms are legally agents, then that has particular legal consequences and implications. So in this paper, I sort of try to tackle two questions, really, two main questions. The first one is, are online platforms that facilitate transactions between suppliers and customers agents of those suppliers? So in this paper, I'm only looking at transaction platforms, and specifically, I'm looking at 6 of those major transaction platforms, namely Amazon, Amazon Marketplace, Uber, eBay, Airbnb, Booking.com, and Apple App Store. And the first question I ask is, are these transaction platforms agents of the suppliers that reach customers via the intermediation of these platforms? And to sort of summarize the findings of the paper, in case I run out of time, the first contribution of the paper is that I answer that question in the affirmative, and I do that by looking at different areas of law. So common law, commercial law, tax law, employment law, and competition law. And I try to derive the principles of agency, because agency is a concept that we see across these areas of law. So I try to derive the principles of agency from those areas of law. And then I go through the standard contracts, the terms and conditions of those 6 platforms that I mentioned. And essentially, I apply the law as it exists to those 6 platforms as their contracts stand. And I come to the conclusion that these platforms are actually agents of those suppliers, which reach their customers through the intermediation of the platforms. And this has a fairly important implication for competition law, and that's because we have the so-called single economic entity doctrine in competition law, and the doctrine exists in sort of different degrees in different jurisdictions. I look in particular at the EU law for this part of the paper, but also refer to the US law where relevant. And the single economic entity doctrine in EU competition law means that for an agreement between parties to be subject to the prohibition in Article 101, which prohibits anti-competitive agreements and concerted practices, those two entities have to be both separate undertakings. And if the agreement takes place within the same economic entity, then competition law prohibition of cartels and concerted practices will not apply to those agreements that take place within the same economic entity. So one of those situations where Article 101 would not apply to an agreement between two different entities is if those two entities are a principal and an agent, because essentially the agent is seen as part of the single economic entity with the principal, and therefore the agreements they reach between themselves are not caught by the prohibition of Article 101 to the extent they relate to essentially directions or the conditions of the sale of the product of the principal via the agent to the customers. And if this is applied to platforms and platforms are agents, then that means that we have a situation which I might sort of ironically call a platform gap. And that's because if online platforms are agents, then potentially their agreements with their suppliers are outside the application, the scrutiny of Article 101 altogether. Then that question gives rise to a second question. Well, should the platform gap be filled? If there's a gap, should that gap be filled? And I say in the paper, I argue that there's one particular situation in which this gap should be filled. And that is where the platform in question competes with its own suppliers. And I develop a concept of competitive neutrality to facilitate this filling of the gap. And I use the fact that agency is a fiduciary relationship, which requires an alignment of interests between the principal and the agent, to argue that where the platform or where the agent starts competing with its principal or the suppliers here, then the fiduciary relationship is essentially violated to such a degree that this agency exception should no longer apply. And in that context, the platform should not be deemed as the agent of the supplier anymore. So that's in a nutshell what really the paper does. And let me tell you a little bit about agency then. So agency is not unique to competition law. In fact, agency as a delegation model is much older than competition law. And therefore we look at, in a common law jurisdiction, we look at the case law and agency, and we look at commercial law. And whichever area of law we look at that has an established concept of agency, we see that agency is a fiduciary relationship. This is not recognized as a criterion in competition law, and I'll talk about the competition law concept of agency in a moment. But in essence, agency is a fiduciary relationship, and in law we have a particular definition of agency. So agency is the fiduciary relationship between two persons where one of them gives consent that the other should act on his behalf so as to affect his legal relations with third parties, and that other one so acts. And in general, when we talk about agency in law, we mean a situation where one party has the authority to change the other party's legal position. And that's quite important in terms of distinguishing agency from different relations, different delegation models. But if we look at the common law, for example, we see that there are also relationships which essentially lie on the boundaries of agency, where the law may find a party to be an agent, despite that party not necessarily having the authority to change the putative principal's legal relations or legal positions. So estate agents are, for example, that type of agent. So they're generally seen as agents from a legal point of view, but they're sort of on the outer boundaries of agency, really. And the fiduciary relationship means that the agent should not act for her own profit regarding the relationship with the principal, and the interests, the commercial interests of the principal and the agent should be aligned rather than adverse to one another. Now, interestingly, in common law, fiduciary, at least in English common law, fiduciary duty does not necessarily prevent the agent from being able to work for competing principals, under certain circumstances. An important one for my purposes is that fiduciary duty doesn't prevent an agent from being able to work for competing principals if the nature of the agent's business requires this. Another circumstance is where the principals consent to the agent working for competing principals. So that's sort of agency in a nutshell in commercial law and in common law. Now, in competition law, agency and the agency rule, which essentially immunizes agreements from the application of Article 101, is not built on such a fiduciary relationship or a concept of fiduciary duties, but it's built more on the assumption of risks. So agents are defined in a very similar way in competition law as they're defined in other areas of law. An example is how it's defined in the EU Verticals Guidelines, which defines an agent as a legal or physical person vested with the power to negotiate and or to conclude contracts on behalf of another person, so on behalf of the principal. And if you look at the competition law case law, the key issue seems to be whether the agent assumes financial or commercial risks linked to the sales or performance of contracts entered into with third parties. And there are two important points in that statement. The first one has to do with risks. So whether or not there is a relationship of agency depends on whether the agent is assuming any significant financial or commercial risks on that market. And if the agent is assuming significant financial or commercial risks, then it's unlikely that it's acting as an agent. It's more likely acting as an undertaking in its own, for its own sake, essentially. And the other important point there is the agency exception only applies in the context of restrictions of competition that are found in the contracts that are entered into by the agent on behalf of the principal with third parties. So it's only in relation to the contracts on the relevant product market or the service market, whereby the agent is facilitating contracts for the principal. Any other restrictions of competition that may exist in the contract between the agent and principal, which don't have to do with the contracts on the relevant market that are entered into with third parties, will still be subject to competition law. And I think a distinction that we have to make here, which sometimes goes unnoticed in some of the commentary, is that this means that we need to distinguish between two markets. And the first market, therefore, is the market on which the agent offers its agency services. And the second market is the relevant market on which the agent offers the principal's products or services on behalf of the principal to potential customers. And it's only restrictions of competition on that second market that are essentially immunized from the scrutiny of competition law. And also, I argue elsewhere in the paper that I'm not going to have so much time, I don't think, to go into today, is that when we're looking at investments, for example, and risks, we also have to distinguish again between these two markets. So we have to ask the question, if it's about risk, well, is this a risk that the agent is taking for its agency business on the agency market, where the agent essentially offers his agency services to potential principals, or is it a risk that the agent is taking on the relevant product market, where the agent is facilitating a contract for the principal? So I guess I could really summarize sort of answer that I reached for the first question in the paper, which is the question of, are these platforms agents of their suppliers? I could probably summarize that in one sentence, which would be, if it looks like a duck, it swims like a duck, and it quacks like a duck, then it probably is a duck. And I think that sort of summarizes why these platforms are agents, because I think if they're not agents, I'm not sure if we have any concept that would cover them. And so to reach this conclusion in the paper, I go through, as I said, the principles that I derive from different areas of law, and I look at the terms and conditions of these platforms. And when you apply those principles to the terms and conditions, I think the conclusion is that on balance, these platforms that facilitate transactions for their suppliers are agents. So I'll walk you through some of those principles which suggest that they're agents. First of all, every area of law really starts from the point of what does the contract say. And if we look at the contracts of these platforms, we see that half of them claim to be agents, half of them claim not to be agents. For legal purposes, that it doesn't matter so much essentially, because it's all about the legal nature, the actual how the real sort of facts of the relationship rather than what it says in the contract. And if we look at the commercial activity that they're engaged in, we see that all these transaction platforms are engaged in more or less the same activity of facilitating contracts between different parties. And they don't own the product. So platforms that are facilitating contracts for goods, they don't own the product. They don't keep stock of the product, and they don't normally contribute to the costs of supplying the customer. And with the exception of Uber, of the platforms that I looked at, and I think Uber is a bit of an outlier for different reasons, these platforms also do not set the price. And interestingly, in commercial law, influence on price is not really prohibitive of agency either. So the agent could be setting the price and could still be legally an agent. This seems to be different in competition law, and competition law, I think, takes a different view on pricing power, which it sees as part of the setting of a commercial strategy. And I said that Uber is a bit of a special case here, and part of the reason Uber is a special case is because Uber is subject to regulations like other private hire companies, and those regulations, at least in the UK, essentially impose on Uber the need to suggest the price. Platforms are also not engaged in buying or selling the product, so they're not engaged in resale. And the contract in all these platform cases is concluded between the supplier and the consumer. And we see that in agency law, in commercial law, even if the intermediary simply introduced parties to one another, this could still be sufficient for a finding of agency. So in the UK in particular, we have a couple of tax cases, actually, tax disputes, because in tax law, it's quite crucial to know whether the party is an intermediary or not, because tax liability depends on how you legally characterize the relation between that party and another. We have several cases in the UK where we see that essentially platforms have been found to be agents of suppliers. So a particular one is the Secret Hotels 2 case that was decided by the UK Supreme Court a few years ago, where you essentially had an online travel agent very similar to Booking.com and others. And in this case in particular, the agreement was completely one-sided between the hotels and the website. The website was a much larger undertaking and had a lot more bargaining power than the hotels. And in fact, the agent here, or the online travel agent, was actually fixing its own commission. And nevertheless, the Supreme Court here decided, on balance, this is an agency relationship. And this differs quite significantly from what we see in Europe, for example, where in the Uber Spain judgment, the Court of Justice found that because Uber has decisive influence over the conditions under which drivers provide their services, this suggests that Uber provides a transport service. And similarly, Bundeskartellamt has rejected this possibility of agency in both the Booking.com and the HRS case, where it looked at MFN clauses, mostly on the basis that because the agent or the putative agent is so much more powerful than the other party, this can't be an agency relationship. So these judgments and decisions are in sort of quite stark contrast to the situation in actual agency law, where agency law doesn't necessarily assume the principal has to have complete control over the agent. And I think in some of these cases, we also see that the courts and authorities see certain controlling terms, whereby, for example, the drivers who are the suppliers in Uber's case are subject to rating systems and so on. And for example, the rider cannot have the details of the driver and vice versa. These look like controlling terms, but actually this is where the two-sided markets theory sort of kicks in. We can actually see that these terms are also ways by which the platform essentially avoids disintermediation and the collapse of the network effects. Now, I'm moving on. I know I have 2 minutes. So in these relations, we also see that the commercial interests of the platform and the supplier are normally aligned in a given transaction. And that's because if a supplier wants to sell, I don't know, alarm clocks on Amazon, Amazon is only going to generate any revenue from that relationship if that alarm clock is sold through the intermediation of Amazon. So both the supplier of the alarm clocks and Amazon, the platform, have interests that are aligned. They will want to essentially conclude that transaction, which will be a profit for the supplier and a commission for Amazon. And this reflects them being in a vertical relationship for competition law purposes. And that's the case even if there's no exclusivity. And in competition law, we see that again, there's a distinction between how competition law sees exclusivity. So whether the platform has to work for one principle, whether the agent has to work for one principle, or whether it's okay for it to work for more than one principle. Again, in agency and commercial law, this is not a prohibitive situation that would mean that the agent is no longer an agent, but competition law takes a different view. So all of the platforms are remunerated by commission, and only if there's a successful contract that's concluded on the platform, and none of them seem to take any significant financial risks on the relevant market. And here we really have to distinguish between taking risks on the relevant product market and taking risks and making investments on the market where the agency business sits. And for competition law purposes too, the agency business will continue to be a separate undertaking for its agency business, and it will be part of the same undertaking with the supplier for the contracts that it facilitates for the supplier. So the next question then becomes, if these platforms are agents, that's my timer telling me that I had 20 minutes. So if the platforms are, if the platforms are agents and essentially they come out of the scrutiny of competition law, should this gap be filled? And I say that that gap should be filled in one instance, at least in one instance, and that's where the fiduciary relationship between the platform and the supplier is violated to such a degree that essentially the whole essence of agency collapses. And I say that that happens where the platform itself starts competing with its suppliers. So where they would be in a purely vertical relationship, we would think that they're in a competitively neutral position. But if the platform actually starts selling the same products or engaging in the same services as its principal is also engaged in, then they become competitors. And where that relationship turns into a horizontal one, I think essentially the fiduciary relationship collapses, and also the rationale for the single economic entity doctrine no longer holds. And therefore, in that case, the contract between the platform and the supplier should be subject to the full application of competition law. Now, to conclude, this platform gap has not been recognized by the competition authorities, at least in Europe, or the courts. And I think that they need to tackle this question head on, whether the platforms are agents or not. And I suggest in the paper that there should be an explicit rule for this in the verticals block exemption regulation when it's revised. And that rule should exclude the application of the agency rule to platforms that compete with their suppliers. Because otherwise what's happening is that we can see different treatments of the same business model, sometimes the same business itself, in different areas of law, like commercial law, tax law, employment and competition law, and they're coming to mutually exclusive interpretations of the same business model. And that can't be good for business or legal uncertainty. Thank you.
I think one of the real issues with agency is that we have a concept that is very important to a lot of practitioners because it creates, or supposedly has created in the past, legal certainty by taking a whole set of vertical relationships out of scrutiny from competition policy. And lots of people would really not like to lose this because the legal certainty would be going down. At the same time, there's really the question of whether the concept as it is set up is actually relevant to the questions of competition policy and whether actually that type of safe haven that's being created has anything to do with the likelihood of competitive effects or not. And I think that's a somewhat different angle than, than Pinar has on this. But I think there's a really fruitful potential further conversation that is to be had between economists and lawyers. And I think before I kind of give my view on some of these issues, let me first of all explain that this is a typical issue where economists and lawyers sometimes have difficulties talking about the substance, because the law makes distinctions very often between observable characteristics or institutions, very often just to be able to define who is the addressee of the law. On the other hand, economics treats institutions as equivalent if they generate the same incentives. So for us, it's completely irrelevant whether it's called agency or anything else. If the vertical structure generates the same incentives of the participating parties, then whatever is characterized as typical identifying patterns for agency relative to something else plays no role for us whatsoever. And as you will see, that is kind of one of the big problems that one would have from the economics point of view in kind of recognizing or understanding what agency should actually be. So for example, as an example of how we're treating things similarly and the law sometimes treats them differently, is if you take exclusive dealing with a penalty for breach of the exclusivity clause, that essentially has the same effect in economics as loyalty pricing. But you've just had 2 or 3 weeks ago a decision by the German Supreme Court that the as efficient competitor test would apply to loyalty pricing, but not to exclusivity rules. That's something where an economist would just shake their head and basically say that doesn't make any sense, because it's just basically pushing firms into certain business formats, which has as a push no economic, makes no competition policy sense by itself, but may actually be undermining efficient organizational structures. So if the arrangement is that are considered vertical restraints in one institution are exempted agency, we as economists would ask the question, what is the underlying incentive problem that distinguishes them? And I think the unifying theme of Pinar's summary of the law with the single entity doctrine has really 2 elements. One is this conflict of interest ideas, which is somehow related to some risk, which is all about aligned incentives or not, with the idea that if your incentives aligned, then you're essentially a single entity. And the fiduciary duty that basically says if you have that duty, your incentives are also aligned. But the problem for an economist are that all incentive contracts, even if they're not written in an agency context, are actually meant to align the incentives of principal and agent in the economics sphere. So basically between the producer and, say, the retailer. So why are some illegal and others not? That's a question for us that's somewhat hard to fathom. So let me take these issues one by one, and I think that I probably also have to stop very soon in order to still allow a little bit of a discussion. So let me take the conflict of interest theme first, which has this element that the agent does not take the ownership of the good, first of all, and that there's commission-based payment instead of you paying like a wholesale price to take ownership of the product that then you resell. Now I can see how from a legal logic, those are 2 very different transactions, but from an economic logic, that is irrelevant for economic incentives. The economic incentives actually do not depend on who has authority to, do not depend on who owns the product, but basically who has the authority to make the pricing decision and the effort decisions. And I've put this little white rimmed box on the lower right-hand side of my slide, which kind of shows you how that kind of comes about. The first one is transferring ownership, where you have a price, and the price then gives you a margin over your retail cost, say, and the wholesale price at which you've bought the unit, and you're maximizing profits in that way. In a commission-based system, you get a proportion of the price that you set. That proportion is rho. You pay the retail cost, essentially, and you're maximizing the profits over price in that way. Now, you can rewrite the maximization problem by dividing everything by rho, that royalty or commission rate. And essentially what you see is that that's just scaling up the costs because the commission rate is below 1. So again, you have higher costs than you would have otherwise. And you can calculate what the wholesale price would be that is equivalent to a given commission. And basically what you get is the double marginalization problem in both cases. While the argument in law is that you have no difference in incentive between the two parties in agency, while you do have outside of agency. No, that's wrong. The conflict that we have about double marginalization exists quite independently of whether there is a royalty or commission system or whether there's a wholesale price. So whether you're actually transferring the good doesn't really matter in the economic models of incentives and the competitive effects of vertical restraints. The same kind of issue comes up really with this consideration of business uncertainty, which I think is in the mind of lawyers really related to the transfer of the good. And it may not be risk in the sense of economists, because the first thing we think about when someone says, well, this is a relationship where the agent doesn't bear the risk, we're basically saying, but any contract is also about allocating the risk between one and the other party. So by basically saying one particular contractual form is legal, the other one is not, that just allocates risk in a finer way, seems really weird to an economist. So, and what's the risk that's meant by transferring the good? Well, it may be liquidity risk or risk in trade credit, because when you're holding the good, you have to give up some money and therefore your liquidity goes down. But then the question is, what does that have to do with competition concerns and competition itself? So really, from an economic point of view, any vertical arrangement, there's an economic conflict of interest, and the contracting tries to resolve that and align the incentives of the parties. So what about that second theme, the fiduciary duty theme? That's actually something we understand much better, and that is what Morten referred to when he was talking about the boundaries of a firm. So fiduciary duties makes economic sense when they're incomplete contracts, and you have to think about the allocation of residual control rights. So one of the problems that you have if you can't write a complete contract is that you may want to delegate to an agent who has better scope or better knowledge or better information to actually make the contract with the buyers and sell. But you cannot write into a contract what exactly the agent has to do in order to conclude the sale. Now, in those circumstances, you may have general clauses that give you very high-powered incentives where you say, look, you have to deal with this as if you were me and not look at your own incentives, but look at my incentives. And if you don't do that, I can fire you, and otherwise I can't fire you. So you're generating a contract with very high-powered incentives in order to overcome the problem that you have an incomplete contract. It's very similar to, yes, I'm coming to an end, Morten. It's very similar to things like FRAND in an SVP setting. Now, this gets us to the point about the modern theory of the firm. The question really that's being asked here is, where are the boundaries of the firm? And should we say it's in the firm or outside the firm? If it's outside the firm, it has competition relevance. If it's inside the firm, it doesn't. That is attractive, but what it overlooks is that we have lots of contractual forms that go beyond ownership in which we can allocate control rights. Franchising does this by allocating some control rights to the franchisee and some control rights to the franchisor. In labor contracts, all the residual control rights are with a firm. In agency, there are ambiguities about this as well. So taking something as a primitive, namely that I'm vertically integrated, while I can replicate the vertical integration with a contract, but make the contract illegal, seems to be something that is in conflict with each other. And so my conclusion from this is that we have to look much more at the issues of where do the competition issues arise and make our exemptions conditional on that instead of focusing it on definitions of the boundaries of the firm. And I'm going to stop here because my time is at an end.